So item 1 to 4, notice Micah's query. 1, 2, 3, and 4. His info Mr. Mubarak is there. This is under which provision? No. Punishment. He's been sentenced under which? 302. Okay, 302. And in 1 to 3, you see, point Micah's query. Notices in POCSO matters through jurisdictional police station. Okay. Admitted.
Item 4.
I will be in this item 4. I allow when after receipt of LCR, TCR. Okay. 1, 2, 3, 4 orders passed. Hey, Mubarak.
Time to kiman din siya? After
5 weeks.
Date.
Did the नया फॉर्म है उसमें होगा नोटिस का मेरे चेंबर में है नोटिस करने आपको they will be giving
After 5 weeks, date is the daily list item 5.
now the person call for the applicant as per office note dated 18/3/2024 answer of notice or ID card has not been in respect of respondent has not been received. List before the Lahore court for passing appropriate orders as regards service of notice and respondent 2, and thereafter the matter be listed before the court.
মানুহে থিয় হৈছে তেওঁ কৈছে আইটেম 5 ৰ নামটো কৈছে প্ৰণৱজ্যোতি গগৈ মই ধৰিব পৰা নাই কথা
কি ক'ব হৈছে হা এইপিনে আহক
এনেকে তাতে
Okay, yes.
the mediation failed. It was sent to mediation, it has failed.
Yes. Tested only on the ground that only 3,50,000 will be given on one time without giving the proper opportunity as a trial court.
Just
What is the court below? By extending power under section 25, one time court has without any application from either party. Court on its own has the power of court has provided one time only.
one time
One time eligible. In the penalty devotion.
during the pendency of the proceedings.
Yes.
Proceedings has not been terminated.
Yes, but that is while yes, while hearing the divorce matter, since the Lanet court below as the point of the case matter,
No. It has been not during the pendency. There is a decree of divorce already. After that, it has been given. So what is wrong in the order?
that the opportunity is not being given properly given. That is one of the problem. So had opportunity given by we would have tried to reduce evidence in this regard, in the particular in this regard, regarding one time element. Yeah, my lord, a material skip from there, but that is a different thing. But we did not apply for one time element. They also probably did not apply that. So, on his own part. Then look, just
So you don't want money.
I want my only my I have two daughters, man.
Okay.
I have two daughters.
Where is the impugn order?
You know, my not stage 20 page 24, my lord. Page 20.
Yes.
May I read my lord?
Just read the operative part.
Yes, yes. What is part, my lord, regarding this one time?
Page 35, my lord, para 15 onwards.
In the above backdrop, this court therefore feels that a suitable amount should be awarded to the petitioner towards alimony. This reveals that the record that two daughters of the father are now major. At PW2, the elder daughter is a dance teacher. That is not correct. My dance teacher, my lord, what happened? Somebody come, sometime I used to teach, man. I'm not teacher, professional teacher. Dance teacher, and the younger one is a student of degree, third semester. The petitioner has stated that she does not have any income. As such, she
This-
is
this,
eligible-
These tutorial classes, Ellen, they are not teachers.
that is not with that degree.
No, we don't know. You said that, you
Yes,
said
of
that, and therefore they are also teachers.
course. That is wrong. But now she is not doing that, doing relevant period she used to do that. So according to her, the respondent is a first class contractor under Education Department, Government of India. During the hearing, the petitioner produced list of contractors which she obtained resorting to RTI, wherefrom it appears that respondent is a class one grade contractor. The respondent also admitted the same in his evidence, but she has stated that he is a contractor only on record and he did not get any work order ever. Further, according to the respondent, he is living below the property right. As such, the government has sanctioned a house in his favor as an exhibit E is the said house sanction letter. The government also issued job card under pension scheme ballot as exhibit G and the ration card by exhibit F in his favor. The above factor makes this court inclined to believe that the version of the respondent, though his name is registered in the list of protectors, it is only on record. The respondent, by adducing evidence, has contended that the petitioner is a tailor by occupation, which received support from the evidence of PW2, who has stated in her evidence that her mother works as a tailor. Well, that is also valid. Furthermore, the respondent produced the photograph of the tailoring shop of the petitioner filed exhibit C. The respondent has further contended that the petitioner is the owner of vehicle exhibit B and B1 and are the document in respect of the vehicle. The respondent in his evidence has stated that earlier that she had a shop, but for last 10 years, the shop is closed, which the petitioner also admitted in her evidence. According to the respondent at present, he is a daily wage earner. Petitioner has produced land record obtained under RTI, wherefrom it reveals that the respondent has landed properties along with other portions. Having regard to all the attending circumstances, I consider it just and proper to award rupees 3,50,000 to the respondent wife towards permanent alimony. The respondent will be at liberty to pay within 6 months. Not within 6 months. But here, my lord, she no longer is a tailor, my lord. During the relevant period, she had to do, my lord. She had to do to for the livelihood of our two daughters and herself. And another important thing. Now, disclosure statement, my lord, has also made it clear, my lord, he is earning 49,000 per month. On record. That is his. So that is my. So if it is calculated, my lord, two daughters are married, my lord, they are studying, my lord. One daughter is studying, my lord, and she without income, my lord, well, maybe for tailoring sometimes. She has a permanent tailoring shop. She used to work in it. So those aspects had my lord, had it been a case for my lord, one-time settlement, my lord. We, my lord, some opportunity had some opportunity given. Then, of course, the income of the respondent, all this thing, more elaborately, my lord, could have been brought on record. Even then, my lord, his landed properties are there. That is, his disclosure statement also disclosed by lord. He has a landed property of lakhs, of more than 8 lakhs probably by lord. Valued more than 8 lakhs. And he is earning on his own, my lord, more than 49,000 my lord per month. Now, 3,50,000 divided into 3 my lord, two daughter and wife my lord. How much it will come, my lord? The situation as such, I have to take some money from this 3,50,000 my lord. When they deposited my lord, I withdrew my lord. It had to my lord. That's how he will. That is my humble submission, my lord. On record, my lord, is your lordship. There is a disclosure statement of. my
Did you,
last
did you,
time,
did you
my lord.
withdraw the money under protest or you accepted it?
No, I have to, of course, sir, that, so.
Because once you accept it without any protest, then it will amount to,
I understand, but since my lord, I accepted after filing of this appeal, my lord, after admission of this appeal, my lord, it can be presumed to be under protest, my lord, I have to. my lord. Otherwise, I would have withdrawn the appeal, my lord. But the mediation also, effort has been made, my lord, of course, my lawyer friend also tried, my lord, to make it 5 lakhs, but the party, so I try to help, but the
parties is that the appellant herein had filed an application before the learned Court of Principal Judge, Family Court, Nalbari, under section 13, numerical 1, bracket, again bracket, small I dash A, bracket closed, and within bracket I dash small b, bracket closed, of Hindu Marriage Act, seeking dissolution of her marriage, which was solemnized on 22/2/1995. Post of the said divorce petition was registered as FC Civil number 206 of 2019. Full stop. On conclusion of trial, the learned trial court, by the impugned judgment, held, inter alia, that the parties were living separately for last 18 years, and therefore there was complete breakdown of the marriage between the parties. Full stop. Accordingly, taking note of the fact that that out of the wedlock of the parties, they had 2 daughters, presently stated to be how many years?
Major, both are major.
Presently stated to be major. Lump sum amount of rupees 3,50,000 was awarded as permanent alimony in favor of the appellant by invoking powers under section, by jurisdiction under section 25 of the Hindu Marriage Act. Next para. The learned counsel for the appellant has submitted. It is 18 years or 16 years, your separation, 16 years or 18 years, somewhere it is 16, somewhere it is 18.
2004 onwards, living separately.
2004.
2004.
2004, they are living separately.
From 2004, they are living.
4 to 22 would be 18 years. But somewhere you have written 16 years also.
In para 2 of the judgment, my lord, it has been stated on 2/2/2024 respondents so and so.
No, that's okay, but I'm just clarifying because I find 2 dates.
Yes.
In page 6 of the petition, para 4, you have written 16 years. No. This appeal you are filing in 2022.
It was, that is, it was somewhere 16 years, so that is right.
The learned counsel for the appellant contends that the learned trial court had not put the parties to notice of exercising jurisdiction under section 25 of the Hindu Marriage Act, and that no application was also filed for permanent alimony. First of it is submitted that had the learned trial court given notice to the appellant about its intention to pass orders under section 25 of the Hindu Marriage Act, he would have, the appellant would have led evidence to claim more alimony in view of the two adult daughters she's compelled to, she's raising singly. Full stop. Next, pursuant to the orders passed by the court, both sides have filed affidavit disclosing their assets and liabilities. So it is not disputed at the bar that as per the contention of the appellant, she is having a monthly earning of rupees 6,000 per month, whereas the respondent has an earning of a disclosed earning of rupees 49,000 per month. Full stop. Both next para. While the counsel for the appellant disputes the earning capacity of the earnings disclosed by the respondent, the learned counsel for the respondent has also disputed the disclosure of earning presented by the appellant. Next paragraph. Having regard to the contents of the impugned judgment and order, and taking note of the submissions made by learned counsel for the parties, it appears that the parties were not to notice by the learned trial court of exercising jurisdiction under section 25 of the Hindu Marriage Act. There is no doubt that the court, in connection with this appeal, would have co-extensive power like a trial court to adjudicate the issues. Full stop. However, if the said procedure is exercised, the parties are likely to lose one forum of challenging the factual findings. Next paragraph. Therefore, the court is of the considered opinion that it would be in the interest of justice to both sides that the impugned judgment dated 10/3/2022 passed by the learned so-and-so in so-and-so be set aside insofar as it relates to orders passed under section 25 of the Hindu Marriage Act, without interfering with the decree of divorce already passed, as both sides have not assailed the decree of divorce granted in the said proceedings. Full stop. Accordingly, without entering into the merit of the challenge made in respect of permanent alimony granted under section 25 of the Hindu Marriage Act in favor of the appellant. The court is inclined to remand the matter back to the Court of Learned Principal Judge, Family Court, Narbari, to give a fresh opportunity to both sides to file a fresh affidavit of disclosure of assets and liabilities, and to permit the parties to lead evidence in respect of the that is set aside. Matter is demanded back to the stop. The court is inclined to grant liberty to the respondent, sorry, his appellant, to present an appropriate application before the learned Court of Principal Judge, Family Court, Nalbari, under section 25 of the Hindu Marriage Act, 1955, and within a period of 1 month from this order. In the event such an application is filed within the time allowed, are we required to give?
As expeditious.
Also, the application we filed, the said learned court shall allow the parties to take such appropriate steps in the proceedings as may be permitted in law. And by allowing the parties to exchange pleadings and reduce evidence in respect of the their respective cases, in connection with the respective pleadings, pass a fresh decision in the matter of permanent alimony. Next, it is once again clarified that the impugned judgment dated 10/3/2022 passed by the Honorable Principal Judge, Family Court, Narbari in FC so-and-so is not interfered insofar as a decree of divorce is concerned. Next paragraph. At this stage, the learned counsel for the respondent has submitted that out of the permanent alimony amount of rupees 3,50,000, the respondent has already deposited a sum of rupees 2 lakh before the learned trial court, which the learned counsel for the appellant admits that the appellant has withdrawn this amount. Full stop. One month is okay?
49,000, it is 47,900.
No,
Okay.
only one prayer, my lord. Lordship, this amount is disputed. Because in my written statement, I said she is earning more than 60,000-70,000. The lordship may not record that line, my lord, that it is an admitted.
No,
position at
I've
the
said that you have both disputed.
No, lordship has recorded, it is an admitted position that the petition appellant is earning 6,000.
No,
and
not
the-
admitted. In this affidavit,
Yes,
the parties have admitted. In your respective affidavits, you have admitted that amount.
My amount is admitted, my lord.
And my amount, I agree, that's
He admits his amount,
But
6,000.
that amount does not.
We have
tally.
already recorded that you have disputed it. We leave it
Fine.
there.
Fine. That should not influence the, that's,
That's
that is
okay.
what.
No, we have not passed anything. We said that you have disputed it. If I say you have disputed it, will it
Should not be
influence?
An admission on my part, my lord.
No,
That-
it's not
that is
there.
the only-
No, no,
Lord
it's not
will
there.
take care of that.
It's not there. We've taken care of it.
Yes.
Uh, it's not- Said and court shall decide the matters without being influenced by any observation based in this.
I know. All right. Is there any requirement of referring Honorable Apex Court decision here? Because ultimately affidavits are filed pursuant to that.
No, because you see, this order we are setting aside only on that ground, that opportunity was not granted.
Yes.
It was,
Fine,
it
fine,
ought to be
fine.
there
Yes,
before.
I have understood. I have understood. Review.
Appeal disposal.
The timing 5 utilization. Timing again 5.
Per minute, I have a break.
For orders, item 7.
Mr. Das, having noted you sitting here, I will just inform you that that in those NIA appeals, a trunk load of records have come. So we have asked the registry to list it so that you can go through the evidence and address us. Because at that time, the evidence was not there. Original. There was a dispute about those.
To be hearing the court.
Hmm?
It will be hearing the court.
It is right now in the chambers. When you want, we'll bring it. But we are getting the matter listed some days. Where the bench is now broken, and that bench will be ask the registry to reconstitute, and then it will be listed in one of these days. Ms. Jahan, you will please inform Mr. Mishra and Mr. Gunadhar Singh. Please inform him also that one of these days.
Get the matter listed.
It has to be, because otherwise, this is something I can't do in my chamber. So it has to be brought to for your inspection.
I'll apply.
So it will be listed in one of these days, but if you want, we can ask the registry to produce the trunk here, so that in this spare time, you can inspect. But give a common time to the court master so that it can be brought here. So both sides has to be here. You and Mr. RKD Chaudhary.
Keep the address. Mr. Chaudhary, we will address.
No, but what I'm saying is that all parties should be here when they inspect the records. You just have to tell the court master and he will arrange that trunk to be brought here. Yes, Ms. Sharma.
7 Lordship, there is an office note that notice could not be sent because of insufficient address. So registry now will send it after receipt of the record, Lordship. The record not yet received. And this is the office.
Okay. Ms. B. Sharma and Micah Curie. and as well as Mr. S.H. Boral and APP for the state. Next para. The learned amicus curiae is referred to the office note dated 16/3/2024, which indicates that notice could not be prepared and sent to the respondent number 2, as the address could not be traced out from the from the judgment of the learned trial court. Next para. In view of the comma, the court is inclined to await receipt of the LCR to make an attempt to find out the address of the respondent number 2. Not LCR, make it TCR. From the TCR. Next para. The registry shall send a reminder for the LCR. List after 4 weeks awaiting receipt of LCR. TCR.
Item 8 for orders.
In this case, as per office note dated 23/2/2024, notice has been issued to OC of side of the.
Oh, in fact, I've told my office people to verify whether he has served the notice upon him. Lordship can take it up at 2
Okay.
or after some time.
Okay.
I've told them to find out.
Okay.
Item 9.
9, there is a mistake. I've told my clerk to take steps. It's a state appeal and then there is a delay of 29 days. And there's some mistake. Lordship will give me 2 days' time. I'll take that steps.
As prayed for by Mrs. Jahan and APP, further 2 days' time is granted to take appropriate steps.
So that's what-
Steps for issuance of notice. Issuance of, first,
that's the condemnation.
the notice upon the respondent is made returnable on after 5 weeks.
26th of April.
So it did not-
List accordingly.
Item 10.
Here also I've sent the soft copy and as well as the hard copy to the OC and I've told my office person to find it out whether it was served. But the office note shows that they have not taken fresh steps. But I
It's okay.
sent it.
We'll wait at 2 till 2 o'clock
Gotcha.
to
I've
find
sent
out.
This is Bogri Bari Police Station. I've told them to find out.
Okay. At 2 o'clock.
That's right.
Item 11.
Lordship, here notice was with lordship. Delay was a bit long lordship, but I had given the reason that for last 12 years, the petitioner is in jail lordship and thereafter in.
Oh, yes, I correct. Yes,
I have stated that in fact, that is the reason and because of, they are over.
Mr. Mary, could you get instructions? Huh? So we'll exempt that issuance of notice on respondent number 2. This is 302. We'll exempt it. But Ms. B. Sharma and counsel for the appellant. बंद कर दिया ऐसे बंद कर दिया Opposite. सबको याद करो सबको याद करो as well as Mr. P.K. Nabeel and at CGC. Before that, you say, Mr. S.S. Bora for the learned APP for the state. Also had Mr. P.K. Nabeel and at CGC, who was requested by order dated 16/2/2024 to obtain instructions for appearing on behalf of the informant, who was the commandant of 152 Battalion, CRPF, Basugaon. Next, upon instructions, the learned CGC has submitted that he is instructed to inform the court that the respondent number 2 has since superannuated. Next paragraph. It is noted from the impugned judgment, from the judgment impugned in the connected appeal, that the appellant was convicted under section 302 IPC and was sentenced to undergo rigorous imprisonment for life and to pay fine with default stipulation. Full stop. Having heard the learned counsel appearing for all sides, on court is of the considered opinion that it is not necessary for the court to issue notice on the respondent 2, as the appellant has been convicted under section 302 of the IPC. Next, but accordingly, the issuance of notice on respondent 2 is dispensed with, first of as the respondent 2 is not found to be a necessary party in this, in the adjudication of this, the connected appeal, as well as this application, where the name of respondent 2 is struck off. The appearance, further appearance of the learned CGC is also exempted. Next, the registry shall not reflect the name of Mr. P.K. Mehdi, learned CGC, in the cause list by listing the matter next. About the delay, in view of the explanation tendered. Next paragraph. By this application under section 5 of the Limitation Act, the applicant has prayed for continuing the delay of 2 to 83 days beyond the period of limitation in filing the connected appeal. Full stop. In view of the inordinate delay in filing the appeal, on the query of the court, the learned amicus curiae has submitted that the appellant was taken into custody after passing of the judgment impugned in the collector appeal on 28, 2015. And since then, he is languishing in jail and was not informed of his right to file an appeal through the legal aid counsel. Correct? Full stop. It is only when the wife of the applicant wrote a letter to the Honorable the Chief Justice of this court on 26/10/2023, it came to light that the applicant had not been able to engage any counsel to prefer an appeal against the order impugned in the connected appeal. So it is submitted that in view of the said situation, in view of the said facts, this court approved the request made by the wife of the applicant, and the matter was referred to the Guwahati High Court Legal Services Committee, and only thereafter, by a letter dated 29/11/2023, the learned amicus curiae was the legal aid counsel was appointed, and this application and the connected appeal was filed on 3/1/2024. Full stop. Next paragraph. Although the learned APP has objected to this long delay, but considering the explanation tendered by the applicant and taking note of the fact that the applicant is behind the bars for more than
More than 12 years.
more than 12 years. So it is not from the date of not from the date of judgment. He was taken into, he was in custody during trial also. Because the judgment is of 15. When you say 12 years, that means trial,
The year 2012 he was arrested.
do you have a date? No. What is the date of offense?
Offense is not just, 31/2001.
2001. So if you accept your time of 12 years, he was arrested when?
Files was about to come back. Case was registered,
No, case will be registered when the crime was committed, 1 or 2 days plus or minus.
2015.
Charge sheet was submitted when? It will be there in the judgment.
Judgment is the appeal logic.
Just see that appeal, memo appeal.
It will start from the. Lordship may kindly come to page 19, paragraph 3. Initially, he was granted bail, then he was not there for 9 years. He
Paragraph,
was, paragraph 3, he could be arrested only in the year 2011. Paragraph 3, page 19 of the judgment.
page 19. That's the word, is it that having noted from paragraph 3 of the impugned, if the judgment impugned in the connected appeal that although the crime was committed in the year 2001, But after being granted bail, the applicant was absconding and was arrested only in the year 2011. So therefore, by now he has spent about 13 years in jail. Therefore, the explanation tendered by the applicant is accepted as good and sufficient cause for the applicant not being able to file the connected appeal on time. So accordingly, though the delay is inordinate, yet the applicant has been able to make out a case for countering the delay of 2 to 8 P beyond the period of limitation in filing the connected appeal. As per this application stands allowed. The learned legal aid counsel shall provide a copy of the memo appeal to the learned APP within a week from today. Next, by the registry shall connect and shall register the connected appeal and list the same in the admission column. Yes, item 12. Oh,
This was taken in 2024, shows that the card or answer is very.
you are appealing? Okay. Okay. Mr. Olaskar, counsel for the applicant, as well as Ms. S.H. Boral and APP for the state. Next, Ms. As they, General Counsel has entered appearance for respondent numbers 1 to 9. So she prays for and is granted a week's time to file Wakalatnama. Some more time. You'll have to file objection also. We give you 3 weeks time then. 4 weeks. It is granted 4 weeks time to file Wakalatnama as well as objection positively. Next list on, give a date after 4 weeks.
of April.
Item 13.
This is part of.
Yes.
I saw the delay of 35 days without the draft for delay will that is paragraph 2 of application.
35.
35 days.
Yes, Mrs. Higg, we record your objection and allow this 35 days delay.
The grounds is stated while
How much maintenance you are paying to the wife?
There is some easy case, my lord.
4,000.
My lord, appeal against the divorce, my lord, order. I have to go.
No, Mr. You see, Mr. Singh, you may have a very good objection, but we all know his stature and fees which he charges. Mr. Decker charges a lot of fees. So at 4,000 rupees of maintenance, there's bound to be some delay. Very bad reputation he has for charging fees. Oh, then you have lost your ground. If you're doing it free, then 35 days delay, there's no explanation. We accept his reasoning because it's a mistake of calculating 90 days and 30 days. We record your objection and then allow it. Third, Mr. P.K. Decker, learned counsel for the applicant, as well as Mr. T. Sheikh, learned counsel for the respondent. By this application under Section 5 of the Limitation Act, the applicant has prayed for condoning the delay of 35 days beyond the period of limitation in filing the connected appeal. Next, the learned counsel for the applicant has submitted that the applicant was under a wrong impression that 90 days time would be available for filing an appeal before this court. However, only later on, it came to know, the applicant came to know that at the time of filing of the appeal, the applicant came to know that the period of limitation prescribed under Section 19 of the Family Courts Act to file an appeal is 30 days. Accordingly, it is submitted that due to incorrect calculation of the period of limitation, the delay had occurred. Next, the learned counsel for the opposite party has vehemently objected to the prayer made in this application, and it is submitted that as 30 days time is allowed to file an appeal, the delay is almost twice is more than twice the period allowed to file an appeal. Next paragraph. Although the learned counsel for the opposite party is not incorrect in making the said objection, however, have you noted that the error in calculation crept because of the wrong understanding of the period of limitation, the court is inclined to accept the explanation given by the applicant as good and sufficient cause which had prevented her to file the connected appeal on time. Next, according to this, application stands allowed and the delay of 35 days in filing the connected appeal stands condoned. Next, the registry shall now register the connected appeal and list the same in admission column. Next, the registry shall also reflect the name of Mr. T. Sheikh and
I allow.
I Alam will be senior to you. Mr. I Alam and Mr. T. Sheikh as counsel appearing for the respondent by listing the connect appeal. Give him a copy. He also has to be thanked.
Item 14 for hearing.
The SFL.
He's on legs. In hearing, I think yesterday's matter will take it up first. This partner matter, we take it up there. You come after some time. In the meantime, we are taking our partner matter. Okay, this matter I have been hearing since yesterday, so.
Yeah, I think.
In fact,
Supplementary
the
item
partner-
16.
The partner matter, Lordship has heard it for quite some time yesterday. And something came to my mind. Because there is a direction of the Honorable Supreme Court that in each and every, not in each and every case, the cases under 304, 302 needs to be added in the charge. Rajbir. In fact, in Rajbir's case, Supreme Court said that the cases under 304, there has to be another charge of 302. 302 will be the main charge and 304B will be the alternative charge. But later on, there is a clarification again made by the Honorable Supreme Court that whenever there are materials in the record that 302 needs to be added, then only it should be added. It should not be added mechanically to each and every case under 304B. Now, here what I see is there are materials of 302. Because whether it is believable or not, but then there are materials that she had seen the commission of the offense. So 302 materials are there. So, but then the charges were not framed, charges were only under 304B. So what my humble submission would be perhaps that there is a mistake in the framing of charge. 302, Lordship can see these two cases, I have sent it by email.
Just give the citation, we don't need a printout. Just give the
Yes.
citation.
Rajbir is
Daniel, you can put this.
Explain that document working as a- Email to Paribo, sir. Email.
हाँ.
Email to Paribo.
no, it is also reported in SCN as well.
Same thing, whatever be, same thing will open.
AI 2011, oh yes, 2010, 15 LCC. 2010, 15.
No, give me AI because I have opened up AI.
Acha. AIR 2011 SC 568. Rajbir is a very short judgment, Lordship can see. There are only 12 paragraphs. Rajbir and others versus State of Haryana. It's also in the display board. It's in the display. Lordship got it? Lordship can see the last paragraph. Last but one paragraph. We further direct all trial courts in India. Did your Lordship get the?
Yes.
We further direct all trial courts in India to ordinarily add section 302 to the charge of section 304B so that death sentence can be imposed in such heinous and barbaric crimes against women. Because under 304, death sentence is not there. That was the reason that the Honorable Supreme Court directed that it should be added.
Thereafter it was clarified.
Thereafter, it was clarified in Jaswinder.
Here 2014 SC 841.
Because after that, mechanically, it was done by all courts in India. And then it was shown to the.
AIR?
Supreme Court. AIR
2014.
14 SC 841,
Section 14.
SC 841. Copy of this, 80 years of age. Now here in the Jaswinder, Lordship will see the first paragraph. The short question that falls for consideration in this appeal by special leave is whether the trial court was justified in framing a charge under 302 of the IPC against the appellants and whether the High Court was justified in affirming the order of the trial court and dismissing the writ petition filed by the writ petitioners against the same. Then Lordship will go to the clarificatory order. Paragraph 12 and 13. Be that as it may, the common thread running through both the orders is that in this court in Rajbir Singh's paragraph 13, I am reading, directed the addition of a charge under section 302 IPC to every case in which accused are charged with section 304B. That was not, in our opinion, the true purport of the order passed by this court. The direction was not meant to be followed mechanically and without due regard to the nature of the evidence available in the case. All that this court meant to say was that in a case where a charge alleging dowry debt is framed, a charge under 302 can also be framed if the evidence otherwise permits. No other meaning could be deduced from the order of this court. It is a common ground that a charge under 304B Indian Penal Code is not a substitute for a charge of murder, punishable under 302. As in the case of murder, in every case under section 304B, also there is a debt involved. The question whether it is murder punishable under 302 or a dowry debt punishable under 304 depends upon the fact situation and the evidence in the case. If there is evidence, whether direct or circumstantial, to prima facie support a charge under 302 IPC, the trial court can and indeed ought to frame, this is the word used, can and indeed ought to frame a charge of murder punishable under 302 IPC, which would then be the main charge and not an alternative charge, as is erroneously assumed in some quarters. If the main charge of murder is not proved against the accused at a trial, the court can look into the evidence to determine whether the alternative charge of dowry debt punishable under 304 is established. The ingredients constituting the two offenses are different, thereby demanding appreciation of evidence from the perspective relevant to such ingredients. The trial court, in that view of the matter, acted mechanically, for it framed an additional charge under 302 IPC without adverting to the evidence adduced in the case of Rajbir Singh. The High Court no doubt made a half-hearted attempt. So what I wanted to place is, when there are materials, the trial court can and indeed ought to have, this is the word, they should have added the charge of 302. Here, Bedena, whether she will be believed or not, that is again an issue to be decided.
No,
in the
but,
trial.
but here again, another question will come. You see, in an appeal filed by the appellant, we can't put him to a worse situation than he was. So therefore, the state has not come up in appeal saying that the charges were wrongly framed. So in his appeal, perhaps we can't pose this question and put him to a to a disadvantaged position,
that
then he
position
is already in.
But if he is before your lordship and taking clue from 386, it's like enhancing the sentence.
They can't do it because unless the state comes forward.
But 386 notice has to be given.
So
Lordship,
that's okay. Even to invoke that, we must come at a, there must be something on record, not just out of the blue.
that will again prejudice it, that of course is there. But
Because it's a criminal appeal being heard. Although you may be right, out of 100%, you may be 101% right. But still to do it in his appeal, this is a question which will have to get us. You have to address that.
386 perhaps will be answered with enhancing the sentence after giving him notice. This is not enhancing, but this is like sending it
No.
back.
Because we'll be, you see, first of all, we must come to a conclusion that in this case, ingredients of 302 are available. And then only we can exercise that power. Not merely because the Supreme Court has passed this judgment, that we have to mechanically send it back. So therefore, satisfaction even in this case of this, what do you call, the second case, Jaswinder, he says that it can't be done mechanically.
It can be done mechanically in sending 302 without delving into materials.
Because he's asking for an acquittal. Even in 304, he's asking for an acquittal. For the time being, outrightly, we can't accept your contention.
Not to hear the matter, I
Yeah.
just wanted to point it out that.
That's okay. Good that you have pointed it out.
That's a life, isn't it? That's good. He has been awarded life. ইয়াতে দিওঁ মই অনলাইন পঠাম তাত print হৈ যায় আকৌ। মই গোটেই document টো দি দিব লাগে। তেনে আৰু এটা এলাই answer নাই কি তাত ধৰ তাত jeopardize হোৱা আগত তাত যদি individual আকৌ charge আকৌ charge ৰ পৰা আৰম্ভ কৰে retrial it's like opening out Pandora box. Additional. Don't worry about 319 accused. নতুন trial হলে বাৰু। approval লাগে যে সেইটো। এটা 306 এটা এইটো 306 এটা কেছ নহয় remanding back will continue. That's not. What was wrong? Not a lesser offense. So that's something bad for it. Let's see what the result.
My lord, may it please honorable. Yeah, my lord. As I have already placed yesterday, my lord, with your lordship, that regarding that demand part, my lord. So most vital is the father, my lord, PW2, my lord. So father, my lord, he states that, my lord, regarding mother-in-law and the father-in-law, that there is 11, my lord.
Very good.
Yes. Well, only those lines which are relevant, I will just be missing. So, my lord, here, my lord, that page 11, my lord, last line, my lord. This,
This you are submitting in what, on what point?
on the point of, my lord, not a case under 304B, because demand
Okay, 304, okay. Yes,
Yes, my lord. See that page 11, my lord, last line, my lord. She informed that her mother-in-law and father-in-law and demanded money. 11. And my lord, she doesn't say that, my lord, she was subjected to, my lord. And then harassment and poor living, my lord, in connection with that demand of that amount, my lord. And thereafter in the cross, my lord, you should find page 13, my lord. It's our page 12 last time. During this time, I visited my son-in-law's house approximately 4 times. So 4 times father-in-law visited my lord. Page 12 last, it's our last line. 13 first line, my lord, son-in-law's house approximately 4 times. At that time, she talked about the harassment suffered at the hands of her parents-in-law. Thereafter, my lord, 1 2 line next, my lord. She did not tell me properly as to what kind of torture was meted out to her by her parents-in-law. Just 2 lines. Again, then that same parameter last time, my daughter told me first about the demand for 1 lakh. So given what we find, there is nothing against the husband, my lord. Absolutely silent, and so for the regarding the parents-in-law is are concerned, my lord. One has been charge sheeted, the mother-in-law not charge sheeted. Regarding father-in-law also, my lord, what should find that? That demanded and but that she was subjected to cruelty and harassment for that demand of that same amount that is was not there. And even in the cross, my lord, the next place, my lord, is 14, my lord. Is 14, my lord, that first line, when the demand of 1 lakh rupees was made, I did not talk with Sabi's parents. So normally, my lord, if that demand is there, my lord, they sometimes you have to know what is the reason or what is the whole incident, my lord. Although it was only 1 day, my lord. Or 2 days, only 1 day in between. Now, PW, that uncle, my lord. Then, my lord, PW, 3, my lord, page 15, he says he heard, my lord. I heard after marriage that Hamida had been tortured by accused Sabir and his parents. Page 50. The last line, my lord, then I came to know from Hamida that after demanding 1 lakh rupees from her, her parents-in-law drove her out of the house. That part, my lord, PW. My lord, the father did not that stated that story that my lord, she was driven out for that amount, my lord. Here a new addition of that, from the addition of the earlier part, the uncle says that it was not, my lord, stated by the father, my lord. And here also, the parents-in-law drove her out. Therefore, last line, I suspect that due to non-fulfillment of demand of money, accused will happen. Same here also, my lord, also find there is no allegation against the husband, my lord. Regarding demand and also, my lord, taking her with cruelty and harassment in connection with that demand of the husband. Rather, my lord, brother was absolutely silent, only 1 line also find page 18, my lord. Page 18, my lord. Second, I was informed that prior to the occurrence, accused had demanded. Who is the accused, my lord? is not the accused, only one. Not the accused persons, my lord, or demanded. Possibly, my lord, he refers to the husband, my lord, and he had also assaulted my elder sister. But that part, my lord, IO states, my lord, that part was not stated before the IO regarding assault, my lord. So here also that cruelty and harassment in connection with that demand of dowry is not made out. Then same with my lord, PW5 uncle, my lord. Here he states that my lord Hamida, last line, my lord, page 20. That at night Hamida told her father that her parents in-law and her husband demanded 1 lakh. Father doesn't say about it, my lord. That the husband demanded, my lord. And in the cross also, I heard that demanding money, the accused tortured Hamida.
Just a moment. You are referring to which page?
Uncle, my lord, page
21.
21. Last line. It starts from my lord, page 20, last line. So here, my lord, ingredients of 304B, my lord.
We'll take a short break and come back.
My lord, regarding that category of 304, my lord. So, for the 10, my lord, 9 SCC, page 73, my lord. The case of my lord, Durga Prasad and another, my lord. Here, their charges were under 304B and 306, my lord, in that case, my lord. Para 16, my lord. Here, my lord. Having having carefully considered submission made on behalf of the respective parties, they inclined to allow benefit of doubt to the applicants, having particular regard to the fact that except certain bold statements made by PW one and three, alleging that the victim had been subjected to cruelty and harassment prior to her death, there is no other evidence to prove that the victim committed suicide on account of cruelty and harassment to which she was subjected just prior to her death, which is in fact are the ingredients of the evidence to be laid in respect of 113B of the Evidence Act in order to bring up the guilt against the accused under 304B. Para 17, as has been mentioned here in before, in order to hold an accused guilty of an offence under 304B IPC, it has to be shown that apart from the fact that the woman died on account of burning or bodily injury, otherwise under normal circumstances within 7 years of her marriage, it has also to be shown that soon before her death, she was subjected to cruelty or harassment by her husband or any relative of her husband, or in connection with any demands for dowry. Only then would such death be called dowry death, and such husband or relative shall be deemed to have caused death of the person concerned. Para 18 also, my lord, here also find, my lord, that in that case, my lord, there was no charge under Dowry Prohibition Act, my lord. Like here, my lord, no 498A, my lord. In this case, on one hand, one aspect has to be, another one aspect has to be kept in mind, namely that no charges were framed against the applicants under provision of Dowry Prohibition Act. And the evidence laid in order to prove the same for the purpose of 304B is related to demand of a fan only. Here, that one left. And para 19 also, my lord. Second, in order to bring home a conviction under 304 IPC, it will not be sufficient only to lead evidence that showing that cruelty or harassment had been meted out to the victim, but such treatment was in connection with the demand for dowry. Other please, my lord.
But
Difference.
are you aware of the provisions of Dowry Prohibition Act? When would it apply? Uh, uh, Here is case of death.
The definition of under the dowry prohibition is that it should be in connection with marriage before the marriage, something is demanded during or after.
Before or after?
After is again, how long? I'll place a judgment on that.
No, here it is quite close, but but you see. Personally, I will have a reservation under Dowry Prohibition Act because you see, a defense can be taken always under the Dowry Prohibition Act if such charge was there. That is, I asked for money. There's no doubt about it. It is for the welfare of the girl. Because that is again an exemption.
That will not.
You don't know why, my lord, that cruelty part, my lord.
Yes, I wanted to have a fixed deposit in her name so that
All demands are not there.
all demands are not dowry.
I'll show only one statement. I'll show from the evidence that it is dowry.
It's okay.
In fact, Malo, there is one single bank judgment also, Malo, that is one demand is does not amount to double.
Hmm?
One demand does not amount to Malo 490, there is a single bank judgment, which is easy awareness. That single incident of Milo that, because here there is a single incident of one event. The next is was 2017 Milo, one SCC, 101. That has been also been followed in Then Milo, there are 29 Milo. In proposition Milo, I am just reading it Milo. This simply this presumption as well is founded on the proof of cruelty or harassment of the woman, if for or in connection with any demand for dowry by the person charged with offence. Para 29 minutes.
29.
Presumption as to dowry that thus would get activated only upon the proof of the fact that the deceased lady has been subjected to cruelty or harassment for or in connection with any demand for dowry by the accused, and that too in reasonable quantity of death. That is there, but cruelty and harassment, that is not there. Such a proof is thus the legislative mandate prerequisite to invoke the otherwise statutory maintained presumption of commission of offense of dowry death by the person charged. Next para also, madam. A conjoined reading, para 30, madam. A conjoined reading of the three provision thus predicate the burden of the prosecution to non-necessarily substantiate the ingredients of the two offense by direct and convincing evidence, and we await the presumption engrafted in section 113B of the Act against the accused. Proof of cruelty or harassment by the husband or his. That's 30, madam. Proof of cruelty or
Just a moment. Yes, para 29 then.
that.
Ah.
A conjoined reading of this three provision does predicate the burden of the prosecution to unnecessarily substantiate the ingredients of the two offense by direct and convincing evidence as so as to avail the presumption and drafted in section 133 of the Act. Against the accused. Another proof of cruelty or harassment by the accused or his relative or the person charged is thus the sine qua non to instruct the statutory presumption to draw the person charged with the faults thereof. If the prosecution fails to demonstrate by causing coherent and persuasive evidence to prove such facts, the person accused of either of the above referred offences cannot be held guilty by taking refuge only to the presumption to cover up the shortfall in. Now, para 31 also, my lord, the legislative premature of relieving the prosecution of the rigor of the proof and the often practically inaccessible recesses of life within the guarded confines of a matrimonial home, and of replenishing the consequential void by according a presumption against the person charged, cannot be overused to gloss over or and condone its failure to prove credibly the basic facts enumerated in the section. This justice is the casual. The 32 also, my lord. The 3034B and 113B, my lord. The court of, while often dwelling on the scope and purport of 304B of the code and 113B of the Act, have propounded that presumption is contingent on the facts that the prosecution first fail of the ingredients of the offense of section 304B, as in Shindo versus State of Punjab and echoed in Rajiv Kumar versus State of Haryana. In the later pronouncement, this court propounded that one of the essential ingredients of dowry debt under section 304B of the code is that the accused must have subjected the woman to cruelty in connection with the demand for dowry soon before her death, and that this ingredient has to be proven by the prosecution beyond reasonable doubt. And only then the court will presume that the accused has committed the offense of dowry debt under section 113B of the Act. It is referred to with approval the earlier decision of this court in A. Prema S. Rao versus Yalda Srinivas Rao to the effect that to attract the provision of 304B of the code, one of the main ingredients of the offense which is required to be established is that soon before her death, she was subjected to cruelty and harassment in connection with the demand for dowry. In a recent case, matter, this case, matter 2017 case, matter, it was followed, my lord. That is in 2023 live law SC 241, my lord. I found it in the forward this type of. There are only that is the reason. But the ingredient of 304B, madam, that has to be fulfilled. In the aforesaid evidence raised by the prosecution, none of the witnesses stated about the cruelty or harassment to the deceased by the appellant or any of his family members on account of demand of dowry before her death or otherwise. Rather, harassment has not been narrated by any. It is only certain oral advertisement regarding the demand of motorcycle and land, which is also much prior to the incident. The aforesaid evidence made by the prosecutor does not fulfill the refusal to invoke the presumption in the section 304B or 113B of the evidence. Here, even the section 498 never for the same reason as there is no evidence of cruelty and harassment to the deceased in the event. Now, para 23, my lord. The collective appreciation of the evidence laid by the prosecution, we are of the confident view that the prerequisite to raise presumption under 204B accusation and under 30 of the Evidence Act has not been fulfilled. Having not been fulfilled, the conviction of the applicant cannot be justified. Near date of the deceased being unmarried in matrimonial home within the 7 years of marriage will not be sufficient to convict the accused under 204B and 204B IPC. In that case, the court of death has. Para 11, my lord, then earlier this was referred to in the example.
Para
Para 11, my lord.
11.
That 2017 166 case 121 that has been referred in para 11.
Okay.
Hello. But here from the evidence level, severity or harassment has not been meted out to the unfortunate victim level. Prior to the from before the in connection with the demand of the outcome. It is a husband who is absolutely not there, and with father-in-law, there's a bold statement that he had demanded, and in the court, is that what torture was done was never stated to him, in what sort of torture. But even at the anti-time, my lord, and the unnatural conduct, my lord, of the PW6, my lord. And the delay in sending the FIR number to the Telecom Magistrate. The case was 1994, 5 SCC, case 188. We have para 12, my lord. One eighty. Well done, 39 para 12. FIR in a criminal case and particularly in a murder case is a vital and valuable piece of evidence for appreciating for the purpose of appreciating the evidence raised at the trial. The object of insisting upon prompt lodging of FIR is to obtain the earliest information regarding the circumstances in which the crime was committed, including the names of the actual culprit and the part played by them, the weapons if any used, and also the names of the eyewitnesses if any. Here eyewitnesses, W6 my lord. FIR. Delay in lodging of the FIR often result in embellishment, which is a creature of an afterthought. Embellishment. On account of delay, the FIR not only gets bereft of advantage of spontaneity.
Yes.
On the account of delay, the FIR not only gets bereft of advantage of spontaneity, danger also creeps in of the introduction of a colored version or exaggerated story. With a view to determine whether the FIR was lost at the time it is alleged to have been recorded, the court generally looks for certain external checks. One of the checks is the receipt of the copy of the FIR called the special report in a murder case by the local ministry. We are possibly in Assam, my lord, that is not followed, that, but it is endorsed by the FIR is endorsed by the ministry, seen by the ministry. special report possibly it is not clear. But, that, my lord, that receipt of the copy of the affair was special report in a murder case by the local magistrate. If this report is received by the magistrate late, it can give rise to an inference that the affair was not lodged at the time it is alleged to have been recorded. If this report is received by the magistrate late, it can give rise to an inference that the affair was not lost at the time it is alleged to have been recorded. Unless, of course, the prosecution can offer a satisfactory explanation for delay in dispatching or receipt of the copy of the affair by the local magistrate. Prosecution has laid no evidence at all in this behalf. So why it was late, my lord? After 3 days, my lord. The second external check, equally important, is the sending of the copy of the FIR along with the dead body and its reference in the inquest report. Even though the inquest report prepared under section 174 CRPC is aimed at serving a statutory.
You see, yes, sorry, in fact, you will find in judgments arising out of two states where this plea are taken and accepted by the Supreme Court. This is one is the state of Rajasthan, and the second is this Punjab and Haryana. This is a case from which place? From UP. UP, I am not aware, but these two states I am aware, where they take a lot of pain in these small things, which according to them is very vital because of the dispatch, the delay in dispatch, the delay in what you call registration of the FIR, the delay in what you call getting it seen in before the magistrate. They take exceptions, but here. Because here in the format of Assam Police, in the inquest form, you will not find this given paragraph 11. Down below, you will find about 7, 10, 8 to 10 lines from below. It deserves to be noticed that in the inquest report, even the name of accused has not been mentioned. It is also does not contain the names of eyewitnesses or gist of statements. We don't have that form. Form of inquest does not contain that.
We get sick by that there is a report by it. There is also a person they might have seen by it. There is always a report by it. Brief by it. Substantiated by it. There are only 2 lines I have seen by it in the instant case by it. And when the inquest was done, madam, one IO police officer was there, the first one. And father did not state anything before them. Form possibly not there, I'm not on that level. But brief statements are there.
Police manual. Also give me CRPC. CRPC is not here. CRPC. Let me check it out. Wait, wait. Oh, I'm sorry. Sorry. Page is that inquest report? Inquest report is at which page?
Well, 100. No, I'm sorry. Once.
Inclusive 88.
88. Just give us. Select for. Yes.
Para 30, 12, my lord. Then the inquest report prepared under section 174 CRPC is aimed at serving the statutory function to lend credence to the prosecution case. The details of the FIR and the gist of statements recorded during inquest proceedings get reflected in the report. The absence of those details is indicative of the fact that the prosecution's story was still in an embryo state and has not been given any shape, and the FIR came to be recorded later on after due deliberation and consultation and was anti-tax, giving it color of a prompt false FIR. In account of the informative and notice effort, the FIR is largely value and simplicity. And it appears to us that the same has been anti-time and recorded till the inquest proceeding were over at the spot by given. Next para, my lord. Appears it was a case of blind mother, none of the eyewitnesses were actually present at the scene. The timing of the anti-timing of the affair was obviously made to introduce eyewitness to support the prosecution case. But here we introduce the story of the demand, my lord. And thereafter, my lord, that conduct of the one of the eyewitness, my lord, she did not do anything, that unnatural conduct. Right, that will come regarding that. That unnatural conduct, my lord. Because she did not take any proactive step, my lord, although she was. Another para 15, my lord.
Paragraph.
15, 1 5.
Yes.
As eyewitnesses are undoubtedly deeply interested in the prosecution case, but that by itself cannot be a ground to discard their testimony. It, however, certainly put this group on the guard to scrutinize the evidence more carefully and keeping in view of the unnatural conduct. As noticed above, it appears to us that none of the alleged eyewitnesses had actually seen the occurrence and they were interviewed as eyewitnesses after for deliberation and consultation. It appears to since it was a blind murder that brings only working in account of misguided suspicion of previous enemy. That regarding that PW6 minus, she remains silent for so many days, my that our conduct was unnatural, my and he has been projected to be eyewitness, my to make out a case, my for that purpose, my this case, my lord, it has been now in a recent case, my lord, again referred to, my lord. Here only one that I am.
Ms. Jahan, the Assam police had come up with the form of inquests.
It is in a form manner. In some cases, I've seen it is done in a form manner.
That was prepared and that should be when we resume at the second half, can you get it from your office?
I'll try, because I know it is not incorporated in police manual. It was later done. That format
Later
of
done and
inquest.
improved few days back.
Acha. Registry will be able to, our office.
No, they will not be aware. Because after that, the police issued a notification of that, those forms.
I'll try,
Hmm.
ask Makhan Fukanana.
Here, madam, 2023 live law SC 489, madam. That
But Kai,
earlier that 1994 case has been relied upon, madam, and
Fukan,
para 13, madam. In that case, there was some, madam, interpolation of the dates, madam, time, madam. in the instant case, my lord. Para 13, the Chief FIR was sent to the court on 8/8/1995 with a delay of about 4 days. It is worth mentioning that FIR in a criminal case and particularly in a murder case is a vital and a valuable piece of evidence, especially for the purpose of appreciating the evidence adduced at the trial. It is for this reason that the infirmities in the FIR casts doubt on its authenticity. FIR of such cases may lose its evidentiary value. In Mehra Singh, that earlier case, madam, it has been obtained that on account of infirmities of such as anti-binding or FIR loses its evidentiary value. Thus, this entitles the accused the benefit of doubt. Here, para 20 and 23, madam, that is regarding that unnatural conduct, madam. Although that may not be that much required because anyway, madam, after 133 days, her statement was recorded that itself is factual, madam. It became recording the 161, madam.
Yes, the one which is given us just before he read, concerning the fire.
Yes, now.
Yes. Ms. Jan, just I'll take 2 minutes. Ms. Jan will show you something. There's two orange flag put here.
Orange flag.
Here in this. Once again, I'm recollecting this after about 27, 28 years. And you see first the flag below.
The orange flag.
Yes, orange flag below. No, not the first one, below, second one. Now here you will find this reference to 174. And it says 174 refer to rule 34.
Yeah.
Now come to rule 34, which is the first flag. Now this is how the inquest is to be done under the Assam police. Now what had happened was this, I'm just at random finding it out. This is police of, this is Puducherry police.
Pondicherry police even I've got one form.
You have got the form?
Yes.
Yes, correct. So this is the form. So here you see, this is the questions to be asked. Here the reference to accused and all are there.
But not in the same.
Correct. So here you, there are questions put, the reference to the accused, reference to the so and so, reference to the FIR, those are there. So at times, the judgment of the Supreme Court, when we are referring to, without knowing the context here, because in Assam police, that form of inquest is not there. So every magistrate is writing their own way of form. So therefore, I recollect the police saying that they were preparing a form, but I am not very sure.
Certain cases get it in a form manner.
No, we don't know, but there must be some backing. You see, there is a form used. This form must have some, what you call genesis in some act or rules. Then it will come. So then Puducherry, this is for part of the form and the Puducherry Police Manual and is Form 85. So therefore, we have a sequence, but in Assam that is missing. So that's why I'm asking you that please try to find out if we can get hold of that so that the sequence is complete, in fact.
Otherwise, ours is only a formality showing what are the injuries, nothing more.
No, we don't know unless there is a form, because now that is why these are coming, and now questions are being asked. Even he is referring to, when Mr. Chaudhary is referring to Supreme Court judgment, we just can't wish it away. We'll have to give some answers.
But here he is not, but here he is not challenging that.
That's what he's arguing. He may not have written in so many words.
What
It's
if the FI was sent?
antedated. He says that because the sequence, he is accusing that the FIR is antedated.
Here, no reference about the FIR, neither either in the FIR nor either in the GBA, no reference.
No, the original can be seen.
No, this okay. If you don't have a form with it, it can't be so fatal. Because that's why we have shown you the sequence. This is something I remembered after a long time. You see, I'm growing old. I'm growing old.
But then I think in the original inquest, there will be some reference to GD entry numbers.
No, it's not there.
Not
This
there.
I saw.
Achha.
Take it and see. Not there.
That is, of course, it has to be there. GD entry number or anything.
I don't know, please check it because.
Gotcha.
Not getting. It's not in sequence.
Achha.
The inquest report is down below. The exhibits are at the end.
Hmm.
After these exhibits comes this inquest report. It is handed,
I'll check, I'll check.
kindly handed over. Acha.
Time being item 8.
No, Lordship couldn't get any information. They are still trying to find out whether it is served. Because people have newly joined this, this Choigaon police station. Huh? Soigaon Police Station. I've spoken to that OC. He said, I've recently joined. I'm trying to find out whether it is served. So Lordship will take it up on Friday. He will
Friday.
get the information. Friday. Today is Wednesday.
Okay. Both sides are represented. On the prayer made by Ms. S. Jahan and APP, list on 22/3/2024, so as to obtain information from the officer in charge of Chaigaon Police Station as to whether notice on respondent number 2 has been duly served.
Mayurjan Nisa, they're trying to find out. Same is the case with the other case also.
Then also.
Bagri Bari.
Same Mr. Mahmood is there.
They have Bagri Bari, I have again sent the soft copy of Saimuddin SK to him. He had written me, we are checking. So lodging on Friday.
But do it because otherwise we'll have to take steps. It is
Yes.
very difficult
Otherwise, lordship will call him. I'll get back on Friday.
because his right is being affected.
Yes, that's since long. On Friday.
Okay, 2 days more. Mr. Mahmood. Same order. This is police station is Bagri Bari, Bagri.
Positively on Friday. That inquest lordship, I've tried to find out, but Mr. Fukon had said that he will get it from the police officers, but it's not available in our office. The form, if they have, it's not available in our office. Mr. Fukon, our public was-
No, your AP will not know it. It will be the what do you call it, the establishment of the police. They will
Yes.
able to tell you.
He will speak to them and he'll get it, he said. That form.
Because if not on judicial side, if we can convince the administration otherwise, then it is okay. Otherwise, we'll have to pass judicial orders to have this in place.
Yes.
Because once there are observations by the Supreme Court,
It have-
we have to be followed. Just check in the last order, you will find that police station name. In the previous order, just check it up. You'll find that police station name, maybe.
Now item 16.
Just a moment, we are missing your voice. Chaudhary, we are missing your voice. Okay.
2016, my lord, 4 SCC. Page 96, my lord, that is for my lord delay in recording the 161C.
2016.
4 SCC. 96, my lord, page. That I have given, my
Paragraph
paragraph 20, my
20.
20.
Yes.
My lord, here, I'm reading in my para 21. The statement of PW 25 Mirza Majid Beg and PW 24 so and so were recorded after 3 days of the occurrence. No explanation is forthcoming as to why they were not examined for 3 days. It is also not known as to how the police came to know that these witnesses saw the occurrence. The delay in recording the statement casts a serious doubt about their being eyewitness to the occurrence. It may suggest that the investigating officer was deliberately making time with a view to decide about the shape to be given to the case and the eyewitnesses to be introduced. The circumstances in such case lend such significance to this delay. PW 25, Mirza Majid Beg and Video 24, Mohammed Sheikh, in view of their unexpressed silence and delayed statement to the police, do not appear to us to be wholly reliable witness. And otherwise, there is no corroboration to the evidence from the other independent source either. We find it rather unsafe to rely upon their evidence only to uphold the conviction and sentence of the appellant. Here, my lord, lordship seen, my lord, it was after, my lord, 132 days, my lord. PW9 has started.
We don't know how much this judgment would help you. The reasons are three. Number one, at the time of the incident, they saw the incident. PW 25 and 24, there is a misdescription of the vehicle in which they boarded and came back. PW 25 says that they boarded in a oil tanker and then went home. The driver says that they boarded a truck and then went. And in the hospital, they found the vehicle and then they drove. Now, this second thing is that the Supreme Court arrives at a finding that this Maruti van with which the victim was shifted is not proved to be that of 25, PW 25. And thirdly, the informant who gave this FIR did not say about the presence of this. This. So, in fact, out of three things, one appears to be in your favor, that in the FIR, no mention was made about the victim seeing that. But two other things are distinguishable.
This is more better, man. And it's a case of murder, my lord. And she says that she has seen it, man. And she remains silent, my lord. Can you see for 132 days, man? It cannot be case specific, my lord.
Correct, correct.
So, but the parameters, my lord, here it is the instant is what I have to discuss now. But in our case, my lord, the present appeal, Lord should see, my lord, it is for 132 days, my lord. As per the investigating officer, it is 145 days. But as Lordship has seen and the deputy has also shown, my lord, it's of 2011. So it will be around 132 days. And the conduct itself can be seen, my lord. Because it's not a minor offense, my lord. It's a murder case. She says she has seen it, my lord. And her otherwise evidence also, my lord, 161 and 164.
No, you're right. There's a doubt created because of the fact that everybody will question the girl, because the girl went to the matrimonial home of the victim. and there on the same day occurred. So naturally, people will ask her questions.
She made her uncle, that is the first information. She did not say anything.
She did not say anything.
She said, I was at home, I did not say anything. That part.
You created a doubt, no doubt.
That is a. And it is not 2 days, 1 month like that, and this is not so many days. That too, he says, I was there at that point of time.
Correct. You have created a doubt. Let us see how
Once it is.
you can tackle it.
Getting on that, this money that 313, my lord. One.
But again, there's something which is for you to tell us. Number one, to the IO, there was no cross-examination, creating a doubt. And this, to this witness also, PW6. Also, there is no cross-examination worthwhile to discredit her as a witness.
No, the delay itself, my lord, discredits its my lord. Because the delay itself, my lord. But my lord, putting or not putting that, my lord, because it is apparent or palpably clear from the evidence, that's why, my lord. Palpably clear from the evidence that she remains silent, my lord. And inference possibly, my lord, also can go. Because 302 case not going to the, not stating it, staying there, no threat, nothing. From the evidence itself, my lord. It doesn't say that I was threatened or something like that.
No, she was slapped and put into a room.
That she was not made an accused, my lord. Can we see that lady, my lord? Sister, my lord. She was not made an accused.
But that is unconnected because larger crime was being,
So, my lord, but then also my mother-in-law, otherwise the mother-in-law also not made, my lord. And threat was still, my lord, she was in a room, my lord. She came out and came back home, my lord. That's one. So these are something which lordships can, my lord, in that inference can be drawn, and that is the appreciation possibly, my lord, that can be done by.
okay, let's see.
So that part only, my lord, and that Rina Hazarika's, my lord, judging one that regarding he took a plea, my lord, 313, my lord, that possibly from the judgment I have not found, my lord, that has been discussed, my lord, regarding this defense, my lord, his own, my lord, 313, my lord. SCC 289. Para 19, my lord.
Para
Para time 19.
90.
19.
Oh, acha.
Consequence keep some lines valid from that if the accused takes a defense after the prosecution evidence is closed. Under section 13, so where the state is duty bound under so and so to consider the same. The mere use of the word may cannot be held to be confer a discretionary power on the court to consider and consider such. Because the federal right is an accused, the accused to justice the mere likelihood of the prejudice that may be caused thereof. And the difference of the legal entity or whether it is not the political entity, which are available is an entirely different matter. There has been the business taken under three practices. In a given facts of a case, the conviction may well stand vitiated. To our mind, the whether it is cast upon the court to dispensation of justice to adequately consider the defense of the accused taken under 330 and to either accept or reject the same for reasons specified in writing. That's all, man. Only one thing, Madam, we're here in the judgment, we have seen, Madam, there is he did not take, Madam, recourse to that 113B, Madam. That presumption has not been drawn, Madam, not a single line regarding 113B, Madam. The learned trial court, Madam. In the case of 304B, possibly the presumption can be drawn from that only. So not a single line, Madam. Otherwise,
131A could have been invoked.
Madam.
131A presumption could have been invoked. 113A. B. Could have been invoked.
Most of the judgment, Madam, that is there, Madam. Here, Madam, the Madam, trial court, Madam, he says, Madam, circumstantial evidence, as well as the overall testimony of the 6 months. And that's it.
Okay. Yes.
Maybe the lodge.
In fact, this is a 304B case, so what I need to prove is the 5 circumstances. They attached to section 304B. First is not in death, not in normal circumstances, that is evidently proved by the post-mortem report that it is not in normal circumstances. The doctor writes that the deceased died due to throttling. And the other findings also, Lordship will see PW1's finding as well as the post-mortem report. I've checked Modi's medical jurisprudence yesterday. There a difference is made between suicide and strangulation. And there I find that in strangulation part, bruises will come near the neck area, hyoid bone will get fractured, larynx will get injured. Now here, by seeing the post-mortem report, all these findings are there. Lordship will see the post-mortem report once, which is at page 79. Achha. Yes, Lordship will see page number 79. Lordship will see the relevant part is 80. Wounds is small injury with blood stain on the upper part of the neck. These are all bruises and wounds all around the neck. Page number 80 of the paper.
So bruises and
A small injury is there on the right side of the neck, below right ear lobule, injury superficial. Bruises of 2 centimeter right side of the neck, below right angle of mandible, upper jaw, below jaw, lateral to thyroid cartilage. Bruises of different size of 3 inches long, ward. All these bruises are there. Thereafter, Lordship will see the second part. On dissection, bruising areas, there is subcutaneous bruising with Ham's Asher patch and over thyroid cartilage. Bruises of laryngeal mucosa membrane and laryngeal swelling and fracture of the laryngeal cartilage and fracture of superior herring thyroid cartilage.
herring is not a correct word. It should be horn.
Lordship had said, yeah. So these fractures of thyroid cartilage are indicative of strangulation. As well as Lordship will see the thyroid, the hyoid bone. The hyoid bone, there is, I think there is a finding, vein, larynx and lungs, hyoid bone fracture.
Bruising Ham's and Easter patch over thyroid cartilage. That is the only injury reported.
Yes. Hyoid bone, Then I stand corrected. I saw somewhere hyoid bones fractured.
No,
No, it's not there. And the thyroid cartilage. Achha. Then Lordship will see that ligature mark not found.
the fracture is on the
Thyroid cartilage. And the number 4, mark of ligature not found. So what the normal, the conclusion would be that it is a case of strangulation, death due to asphyxia, throttling or strangulation. The first circumstance that the death was not in normal circumstance, that is proved by the PM's report. As well as the Lordship can also see the inquest that is there also this. Then the second circumstances within 7 years, that is also there. She got married perhaps in 22/5/2013. 14, I think the father wrongly writes in his deposition. Father wrote that it is 22/5/2014, but she married in the year 2013. So, and she died 9/7/2014. So here, 11/7/2014. So she was
13 is not coming anywhere.
13, and uncle says. Father said in page number 11, on 22/5/2014, my daughter got married to Sabir Ahmed. No, I think this 14 is little incorrect. Lordship will see the uncle's evidence. Uncle's means the PW3's evidence. Hamida and Sabir got married in 2013. Fourth line from the top, page number 15.
Who's PW5?
PW3.
No, who is PW5?
PW5 is also an uncle.
He says 22/5/2014.
Acha. Was held. Acha, uncle. On 22/5/2014, marriage between so and so was held. Then she died within a period of 2 months.
That's what somewhere it is written 4 months, somewhere it is written died after.
That father,
No, but somebody said 4 months.
1.5 months, person, no? 1.5 months. Ah, yes. So within 7 years of marriage, her death had taken place. Whether it's 2 months, 4 months, doesn't make a difference here. So here, the first two conditions are fulfilled. Third is cruelty and harassment by husband or relatives. The third circumstance is this. Now, this I prove from page number 11, Lordship has already seen. The father had said, harassed by father-in-law and mother-in-law. He does not speak of the husband. Because what we have to think is not simple harassment. The harassment with regard to demand for dowry, that will have to come.
But
Simple harassment,
what would constitute harassment? According to you?
harassment, cruelty, I think as defined in 498A. 498A, cruelty is defined.
Cruelty and harassment must be when the legislature is using two different words. There must be some reason to use different words.
Two different harassment and cruelty in connection
Because
with
you see,
demand for
cruelty is more harsh
then harassment.
than harassment. Harassment, maybe you see, I may say some loose words.
Anything.
That there itself is an harassment. Harassment can, there's interpretations by Supreme Court where it says that when you refer always to the in-laws home in connection with the demand of dowry, then it itself constitutes harassment. It may not be, it may not be in so much of words.
Yes.
But if I constantly point out to you and say that, oh, you got nothing from your home, your people at your home don't care for you. So I'm not accusing anyone of anything. I'm just giving a broad statement that itself constitutes an harassment. So the legislative intention was to use a lighter word to encompass
Everything.
more.
That's
The horizon is broadened.
Here, of course, that harassment, what kind of harassment
But-
is not spelled out.
But-
Harassment only to the extent that 1 lakh was demanded. And other,
No, but that will not be harassment.
Lordship will see, since that page number 11, since after marriage, accused had been torturing my daughter. This is a very bad statement.
So something must be said.
Had been torturing my daughter. And then 9/7, my daughter came to my house and she informed mother-in-law, father-in-law had demanded 1 lakh rupees from her. Of course, there is, I mean, this has not been elaborated. What kind of harassment? In fact, somewhere I found that what kind of, yes, she did not tell me properly what kind of torture was meted out. Nothing was spelled out, but she did not say. Only that harassment. She was harassed after her marriage. And then on 9/7, a demand was go
You
ahead.
see, when you are sure about the period, you will find a sequence of evidence. Which evidence, please don't ask me, I will not remember so much. A sequence of evidence is that someone says that in the matrimonial home, she stayed for only 1.5 months. And this is father's evidence. And father then says that during this period, he went to the house of the bride for 4 times.
4 times, yes.
Now you see, let us say 1.5 years and 4 months for 4 visits. So it is
Quite
45 days. So that means 1 visit in 10
10
days.
days.
And the girl who is subjected to harassment does not tell her father how she was harassed.
Yes. That is
It's
admitted
not the
position.
case of prosecution that the father was not permitted to meet the daughter. The daughter for one day on 9th came to her own place. So you see, here also we have a happy family where the father and daughter can't speak. Family members and the daughter who died can't speak. The younger sister was in that matrimonial home allegedly on that day.
He also did not say.
They also did not speak.
Yes.
So is it not unnatural?
So what we are on is only with 1 lakh rupees of that was demanded.
Because we
Harassment, nothing is spelled out, nothing is shown. What kind
no,
of
you see,
harassment?
when I reflect back, when I'm accusing someone, I'm 3 fingers are pointing towards me. So when I look at my own home, I find that even if something which is worth nothing happens in the house, all of my relatives come to know about it. And they will come, okay, you're sneezing. Why you are sneezing? So, so the 10 phones will come.
This is a normal thing that we tend to say.
Ah.
We tell others.
And by evening, some of the relatives will come and then ask what has happened. So therefore, you see, when we are accusing of harassment, incidentally, you see this harassment.
The dictionary meaning.
Yes. Harassment. Black's law says words, conduct, or action usually repeated or persistent, that being directed at a specific person annoys, alarms, or causes substantial emotional distress in that person and serves no legitimate purpose. Harassment is actionable in some circumstances. This is not important. This is civil rights. You forget this. So for criminal side, only this much it says. So therefore,
Continuous,
you have to show continuity of harassment,
persistent.
consistent. But if the demand for 1 lakh rupees is made,
Because harassment, there is no materials here. Only that she was tortured after her marriage. That has been stated by so many. 1 lakh is also consistent. Everyone had said that 1 lakh was demanded by her in-laws.
now let me ask you an example. It's in a lighter note. It's just to make you amuse, nothing more. Now you see, I have a friend when he is in trouble, he says that he takes out his purse and then looks at his purse and then he's happy whenever he's in trouble. So I asked him that why you look at your purse, what is there? He said, my wife's photograph. So therefore, when I see that I am happy, that means he wants to say that there is no more hard things in life than this photograph. I'm just saying it in lighter note. I'm not that. It's just a lighter note. Now you see, is that harassment? Supposing I do that, can my family come and say that you have been harassing me? Will it constitute?
Cannot.
Yes or no? Or undecided?
It all depends on facts and circumstances, of course.
So you see, I'm putting this example only for the reason that the intention is not to harass. The harassment would come if that accusation is made to the wife, not merely carrying of the photograph. That would not constitute a, but if I accuse my wife of something, under that circumstance, that may be a constant harassment. Because everything happens, you accuse me. That's why I'm asking. So the persistent is, Black's law says repeated and persistent.
Yes. Repeated and persistent.
So if the victim does not speak out to the family members, does not give the exact reason, and you see the act that the lady came back to her matrimonial home shows that she is not in restraint.
She's not in restraint. She
So-
can come anytime she wants.
She can come, the father visited the house of the victim 4 occasions. That means there is no restriction on
Coming.
part of the matrimonial family to allow the father to meet. Otherwise, he would said that whenever I go, my daughter is taken away inside, I am not allowed to speak to her freely. She doesn't say that. So therefore, harassment appears to be a,
Anything is possible, Lordship knows the 1.5 months of marriage, and she will not like to complain to her father every time.
no, but how do you
She's
make out,
trying to
you are the
tackle-
prosecution,
Uh,
you are the
yes.
prosecution, how do you make out harassment? Presumption,
These are presumptions only that I'm just said that she might be trying to tackle herself, not saying it to her parents. That can be a fact. But then again, I have to show it by evidence. The only evidence is that.
but you see
she
these
was tortured.
presumptions they've drawn can lead to very many circumstances. You see, for an example, in this court setting, me and my sister, we are sitting together, we are not looking at each other. Correct. Can a presumption be drawn, adverse presumption? No. So that's why you see presumption will have to be tested on few parameters which was meet the definition.
1 lakh demand of 1 lakh rupees can also lead to, can also mean harassment from her father. Why will the parents-in-law, they'll demand 1 lakh?
Yeah,